Good morning, Your Honor. Michael Pieknik here on behalf of Mr. Herman. It stands to my right. Mr. Herman, will you tell us your full name, please?
Jason Stephen Herman.
All right, you may have a seat. And we are here for two matters. One is a final pretrial and the other is a show cause for an alleged bond violation for fail to appear for a random alcohol test as ordered on October 28th, 2025. We did have the defendant test before the case was called. And the only thing he's testing positive for is marijuana. Is there any resolution to either of these matters?
Your Honor, it's my understanding that the defendant will plead guilty to disturbing the peace, a misdemeanor under the city code. I will have the exact site in just a moment, and the people will discuss the charge count. Given the results of the test today, Your Honor, I'm also going to dismiss the bond violation.
Mr. Pieknik? Is that accurate?
Yes, it is, Your Honor.
And Your Honor, that would be a violation of section 22-94. That's disorderly person, but it does say causing a breach of the peace if the defense will accept that if it's appropriate.
And is that still a 90?
It's a 90-day misdemeanor, Your Honor.
All right. Mr. Herman, have you heard what the attorneys have said the resolution in this case is?
Yes, I have, Your Honor.
And is that how you wish to resolve it?
Yes, it is.
Can you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Sir, it's my understanding you'll be pleading guilty to what is essentially going to be an added count 2 of disturbing the peace under the city code. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In exchange for that, the people will dismiss the charged offense of disorderly persons drunk, which carries the same penalty with that. And additionally, they will, assuming that the plea is accepted by the court, will dismiss the bond violation. Is that your full understanding of the plea agreement?
Yes, it is, Your Honor.
Back on October 11th of this year, were you on probation or parole?
No, I wasn't.
Were you on bond?
Only this.
Okay. Do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, I do.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, I do, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No,
Has anybody threatened you in any way?
no,
And is it your own free choice to plea today?
yes,
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Then Mr. Herman, to the allegation that on or about October 11th, 2025, while in the city of Cadillac of Wexford County, how do you plead to disturbing the peace?
guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on October 11th?
I think it was Harvey.
The Harborview Apartments behind Family Fair?
Yes.
Okay.
I had went up there, which I had been drinking. I went up there and signed a couple different friends that lived up there, or acquaintances. They told me, every time I stopped by, I think it was late, it was quite late. I didn't want to know that shit or not, but they have different floors there. I went to the right door, but the wrong floor. And I think that stirred some people up.
How did you disturb them?
They said I was being, I heard that they were said I was being loud, like through the hallway.
So what were you doing?
Uh,
Let me ask you, do you remember what you were doing?
Not everything, but I do remember being up there. Somebody, for one thing, you have to have a slide or card to even get in that building. Someone had let me in.
But you don't remember that?
Vaguely. I remember going to the door, but I realized, oh, shoot, I couldn't remember what floor the person was on.
So when you say you remember going to the door, are you talking about the entrance door?
No, the door to the apartment.
Okay. So somehow you got in the building. Do you remember getting in the building?
Yeah.
All right.
It was somebody who was all smoking when they were walking in. They, well, come on in, they recognized you.
All right. And then so you went to the floor that you thought you were supposed to be at, but it was the wrong floor.
Right.
What did you do while on that floor to cause a disturbance?
I think I might have been being a little loud. Because I did talk, over by the library, I talked to a couple people and they were like, oh, you're being loud, that's why somebody probably called.
Do you remember being loud?
Not totally.
All right, counsel, I think we've got a memory issue here.
Your Honor, I think a no contest plea would be appropriate due to demonstrate lack of memory.
Mr. Gaffney, any objection to that? So, Mr. Herman, the people are changing the offer somewhat from you pleading guilty to pleading no contest. And there's certain times in which the court can accept a no contest plea. One is for sufficient lack of memory of the events, and it sounds like that's kind of where you're at. Now, the no contest plea will allow the court to review a document. It looks like it's going to be a police report to determine whether or not there's enough of a factual basis in that report to find you guilty of the offense and for sentencing purposes. Do you understand that?
Yes, sir.
So the no contest plea is essentially accepting guilt or accepting responsibility without saying that you're guilty. Do you understand that?
Yes, sir.
So knowing that, then do you wish to change your guilty plea to a no contest plea?
Yes.
All right. Counsel, I've been provided with People's Exhibit number 1. That is a Cadillac Police Department Incident Report number 25-002934. Mr. Carnes, are you moving for its admission?
Yes, Your Honor.
Mr. Pieknik, any objection?
No objection.
People's 1 is received. Give me a moment to review that. Counsel, do you believe that the People's Exhibit number 1 forms an adequate basis to accept the plea?
Yes, Your Honor.
Yes, Your Honor, I do.
As does the court, I find the plea knowing, voluntary, and accurate. I also find the interests of justice are well served in allowing the defendant to enter a no contest plea due to the demonstrated lack of memory in this event. And that is probably due to intoxication, given that his PBT was a 0.268. As such, I do find the defendant guilty of disturbing the peace pursuant to the city code, and pursuant to the plea agreement, the disorderly drunk will be dismissed. In particular, I find that on Saturday, October 10th, at approximately 2:58 in the morning, law enforcement, Cadillac PD was called to the Harbor View Apartments to a person wandering the floor, banging on doors and yelling. He was identified by one of the callers. And as I stated, his PBT was a 0.268. Are we able to sentence today?
Yes, sir.
Any allocution?
Yes, Your Honor. My client, the court noted the amount of alcohol in the system, and he found himself homeless at the time. He made the poor choice of, when he was homeless, turning to alcohol. Led us here today, but since that time, he has found a partner who is allowing him to live in her home, and in exchange for staying there, he does odd jobs around the house. More importantly, she is a recovering alcoholic and prohibits the use of alcohol in her home. His testing results today bear that out. And taking positive steps, he has very recently been to a staffing company, applied for a job. He's got to go back in and turn in they require you to do it online, and you have to put in the dates of your prior employment. So he's got to go back in and complete that application. He's also applied to the Blue Heron and the Big Boy in town. That's the next step. He's got stable lodging and employment, and he reports that he doesn't feel the need to use alcohol when the situation is okay. So we would ask the court to take that into account in the closing sentence and avoid any probation. I think is a fair sentence. Jail time kind of would derail that little ride. He's taking those little steps. I think jail time might derail that. a little. This would ask the court to consider that.
Thank you, Mr. Carnes.
Thank you, Your Honor. On the one hand, this is not the most serious disturbing the peace kind of incident we've seen from Mr. Herman, and he did test negative for alcohol today. On the other hand, he was causing a disturbance on this occasion, and as you know, several prior occasions in the past. I don't think he's a good candidate for supervision, so I'd ask the court not to impose supervision. I do think there needs to be a sanction of some time, given what defense attorney has said, and again, at least there was no violence this time. I'm not opposed to a community service type of sanction. Costs, although I think he owes a lot of fines and costs, that's why sanction would be appropriate. Jail time is appropriate too, but frankly, given his history. Thank you.
Mr. Herman, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I've been through the court system. I have a drinking problem. Really good. Me and the person I'm working with right now, we get along really good. Rakes leaves, mow the lawn. I've been doing quite a bit of work over there, so I've been out, but I'm also trying to get a job because I would like to help her out also with money and pay my fines. And I haven't been on probation in quite a while because I've been homeless, and anytime I got in trouble, I wouldn't even ask for probation. I would just do time to get out of there. And I wouldn't find community service. One time I did that and I got hooked up with a job, so. I really think that I'm going in the right direction.
How long have you been without the alcohol this go around?
Since the last time. When I got to.
Okay, so just a little over a month.
Right.
How have you found not using?
I feel healthy. Now I'm not just, I drink coffee. Yeah, and like I said, me and her get along great. She talks to me. It's kind of like almost like 88 kind of sometimes, because she has her packs. She hasn't drank anything in 3 years. She don't plan on it. She don't want it around her house. I don't hang out with the people I used to hang out with.
Are you doing AA or anything like that?
I haven't jumped into it, but I wouldn't mind doing it.
Have you done it in the past?
Yes, I have.
What's the longest period of sobriety you've had?
Without being incarcerated,
Yeah.
11 months.
Okay. And how long ago was that?
4 years ago.
And how did you do the 11 months? What did you just do it yourself, or did you go to services?
There was a friend involved, kind of a little bit like this situation, but she ended up moving back down south. Eventually, it's kind of my own things.
If I recall correctly, you had a friend of the court matter too a few months ago. Am I right on that? How's that going?
I was supposed to be paying $100.
Are you making that payment?
I haven't made it all that payment. I paid like 40 so far.
And were you supposed to do something through Michigan Works with them as well?
Yes,
Have-
I was
did you-
there, and then I came to jail, and then I talked to him about it.
What are your thoughts of probation?
I think I can do it. I really feel, like I said, if I thought I even had a thought that, oh, I'm gonna skip this up, I would just do the time.
Do you think it'll help you stay off the alcohol?
Yes, yeah, to have a little bit of thumb on me, plus probation help. They tack on you, hey, you gotta pay your fines, you gotta pay your fines.
So I know we had the miss test, and pursuant to the plea agreement, that's gone, but did you test at all with us before today?
It was random.
Yeah.
I had to check on it. It was or so.
And how long ago was that?
well, from 28th last month. Back.
All right. Well, Mr. Herman, I normally wouldn't put somebody on probation for disturbing the peace, but I think, this disturbance was clearly alcohol related. And you're telling me that you have an issue, and I want to hopefully give you some services to help that. And I know in the beginning, there's a lot of motivation to stop drinking, but I also know as time goes on, that urge starts to creep back in. And so I do find reason to put you on probation. So I'm going to do that, not necessarily as a punishment, but more as to help you. But I'm not going to do it for a very long time, because I also don't want to set you up for failure either. And I'm not saying that you would, so don't understand me, but I also understand the longer we put somebody on probation, the more chances there are for them to screw up while on probation. So I'm going to do a 12-month probationary period, but you are eligible for early release. So if you've done everything that we asked you to do, you could be released at that 6-month mark. During that time, you're not to violate any law. Report is ordered, not leave the state without the consent of the probation officer. Keep your contact and employment information current. I am going to order that you not consume any alcohol or illegal controlled substances, including recreational marijuana. I don't want you changing one substance for another. I don't know if you have an issue with that, but you'll be subject to testing pursuant to your probation officer. I'm not going to order the daily testing, but that's something that you and your probation officer can discuss, and you have that option. And I am going to order any additional programming that she feels is appropriate. So I'm not going to order anything specific other than you not consume alcohol. But if she feels as though after you meet that you might need some counseling, she can order that. All right. There is 2 days jail with 2 days credit. $75 crime victims' rights funds fee, $50 state minimum fee. I'll waive fines and court costs along with the attorney fees, because it's going to be $180 beyond the probation. I'm only charging you the 6 months, but if something happens that you end up staying longer than that, you'll be required to pay that monthly probationary fee. So if you do everything you need to do, you could be off as early as 6 months, or it could be as long as 12. All right. Do you have any questions for me about your sentence? Because I have ordered a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. And any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. But I'm going to waive that 20% penalty while you're on probation. So in essence, if you don't have it paid within 56 days after you're released from probation, then that 20% penalty will kick in. All right. All right, you can go out to the front window where you checked in, get your judgment, make a payment if you're able, and if not, get set up on a payment plan. And I'm going to request that you get set up on a payment plan anyways, because you owe the court quite a bit of money, about $4,200 going back to 2015 or 16 without any payments at all. So get set up on a payment plan. All right. And then you'll need to go downstairs to district court probation and get signed up for probation. All right. Thank you.